Justice isn't just about the law. It's about the people who fight for it. I'm Jennifer Long, CEO of Equitas, where justice isn't a concept, it's a commitment. And this is Just Champions. This season, we're breaking down the most critical court cases shaping the fight against sexual violence, intimate partner violence, stalking, and human trafficking. Each week, we sit down with prosecutors and scholars to break down the decisions that define justice and to discuss the challenges that still remain. Because the law isn't just theory. It's the foundation of real lives, real cases, and real change. Hi, everyone. Welcome back to Just Champions. I'm so excited to be here today with David Martin, Senior Deputy Prosecuting Attorney in King County Prosecutor's Office, which is Washington State. He's the co-chair of the Regional Domestic Violence Firearms Enforcement Unit. He's a Fulbright specialist and chair of the Domestic Violence Unit. Although, David, some of these things change, I know, a lot. So if anything I've said has changed, please correct me. And a fellow at the Association of Prosecuting Attorneys. So hi, David.
Hi, Jennifer. How are you?
I'm great. Thank you. Great that you're here. And really spectacular because this episode is about witness intimidation and the cases around it and its impact on victim safety, their ability and willingness to participate in cases and the prosecution of their abusers, and the constitutional issues that it raises along with the development of some of the case law. So, of course, when we're doing this, I could think of no better person since you literally co-wrote the book and the article on which the book was based with Professor Bonomi, the Meet Me by the Hill Where We Used to Park, which I personally think is required reading for anyone who's handling a domestic violence case and really anyone handling any kind of prosecution at all, because as with many things, domestic violence cases really give us insight into subtle tactics of intimidation and control that are used in these cases. So again, thank you for being here.
Yeah, you're welcome. Thank you so much. I really appreciate it. It's fun to be able to, I shouldn't say it's fun. It's important to be able to talk about these things.
No, absolutely. Absolutely. And there is an intellectual curiosity that comes with trying these cases too. So in many ways, you're right. It's something horrible, but there's something invigorating about maybe being able to use your interest in history or law or in analysis for good in these cases. So I wanted to start maybe with having you talk about witness intimidation and how it appears in domestic violence cases from your experience.
Yeah. So, God, I've been around a long time now, like 27-ish years or so. And that's also in addition to growing up in a home with domestic violence. I mean, my upbringing was watching my dad, right, abuse my mom, and the police coming to our home and kind of not doing anything about it. So I was growing up pre-mandatory arrest in Washington State. And even though mandatory arrest is today has got a lot of people have a lot of different feelings about it, a lot of those people didn't grow up in a time when we didn't have it. And so I remember what it was like then. And I also think so my personal experience combined with my professional one is I have a lot of different kind of understanding and appreciation for how intimidation and tampering and manipulation work in a domestic violence case. And I think, sometimes we think about it purely in terms of its most stark examples of if you do this, if you testify, I'm going to kill you. And that happens in cases, but it's not as effective as kind of manipulation for a lot of offenders. They know that they can, through a campaign, wear down their victim and their victim's agency and get them to do things that they wouldn't ordinarily do. They're taking advantage of victims' empathy and support and care and using it against them. And I've seen that in a lot of different victims. I saw that in my own upbringing coming up. And I've seen kind of all different iterations. We've got cases where you wouldn't expect it, where you have incredibly violent and terrible threats of abuse and abuse that is going on to prevent people from testifying. And then in other cases with really extreme levels of violence, enormous sympathy appeals that are being used and no threat of violence, even though violence underpins it. And so I think at the end of all of this, and kind of knowing my own father, is batterers, abusers are just far more sophisticated in the things that they are doing than a lot of people in the general community expect them to be, which is why they have a lot in common with those who promote human trafficking, pimps, and the sort. I mean, the human trafficking is kind of like domestic violence on steroids. It's the same techniques being employed in kind of commercial sense. But for individual batterers, they're playing the game at multiple levels, right? They're taking advantage of victims through subtle threats of violence, through overt threats, through using third parties, through any mechanism that they can get their hands on. Their own attorney is being weaponized and the court system being weaponized in the whole thing. And so I think like that just makes me think a lot about our own responses and our own kind of techniques to try and change offender behavior. Right? It's not just like this internal misogyny that somebody has. It's a much more difficult person to deal with.
The first thing I want to say is acknowledge how appreciative I am that you felt comfortable enough to talk about your own experience as a child growing up in an abusive home and how that contributed to your understanding of this. And I mean, I can just add personally, knowing you, our paths cross fairly often, but not consistently. But you're such a thoughtful person. And it's so clear how much each of these experiences have kind of made you as thoughtful as you are about these cases, as an insightful about them, as good of a prosecutor about them. So I just want to thank you for sharing that and ask you, I mean, with all of this experience, what led you to partner on conducting research on this and then looking into jail calls, which I really think was an incredibly insightful for all of us?
You know, for years we knew, and kind of doing the work for a long time at the felony level and the misdemeanor level, we knew when people were in custody that they were contacting victims. And we believed that they were tampering and intimidating, but we didn't, the only time that we knew that is when a victim would come forward and talk to us about it, or we were able to obtain the letters that offenders would send to victims. And we would go about it in really kind of aggressive ways. Like we would pull the logs of the jail to see the phone numbers that were being called from particular cell blocks and cross-reference that for our victims' phone numbers, and then show how an offender would move from cell block to cell block and that same victim's phone number was being called. So we were able to circumstantially prove that they were contacting the victim in violation of the order, which is a crime in Washington state, and then try to circumstantially prove tampering as a result. And we did this for a long time. It was very time consuming. It was very difficult to do. Courts were like, really, you're going to be able to prove this? And sometimes we were able to. And then one day I called over to the jail and I'm like, hey, I need the logs for this time period. And they were like, do you want the recordings? And I was like, yeah, I mean, you have recordings? Yeah, sure. I would love the recordings. So nobody knew, our Department of Adult and Juvenile Detention had just started using this jail call system, but I got the recordings. And this was on a case, I still have the notes from the case, that was pretty borderline. The detective had sent us the case, in our terminology, as an anticipated decline. They're like, I think the 911 tape is pretty good. I don't know if we can prove it beyond what's on the tape. I don't think it's sufficient for your standards. I anticipate that you'll decline this. And I charged the case, and then we made this request. And I got these CDs, right, because that's how they came back then. And I put the CD in, and I remember the first time I listened to a jail call, and this is 2005-ish, is I felt like I was listening to my parents again. It was both a very kind of personal and emotional impact of listening to those calls and listening to people argue about the abuse and listening to the defendant tamper with the victim and her fight back against it. And I remember just feeling very emotional about it. And usually I'm very, very clinical about a lot of stuff that I do because you have to be in this work. And I was impacted by it. And we made copies of the CDs. I sent them over to the defense attorney, who was somebody I knew and was on really good terms with. And I remember getting a very quick call from defense counsel saying, hey, I'd really love to plead to a lot of stuff so you don't add the following things. Can we do that? Is that okay? And we worked the case out, and he pled. And the victim had recanted in that case as well. And you heard very quickly the reasons why. It was this offender's manipulation. And that led to, wholesale requests by my unit over to the jail, tons and tons of litigation in the state of Washington, in my community, about whether or not we could use these calls, also involving a lot of kind of very high-priced local law firms who were brought in by the defense bar to argue this. And I had a lot of junior deputies and others. Shout out to my colleague, Will Doyle, who manages the violent crimes unit in Snohomish County now. Will really led a lot of that litigation at the time and did an amazing job standing up to so much litigation, to the point that we established that we could use the calls. It went up to the state Supreme Court here in a case called Modica. And the court said, hey, there's not an expectation of privacy. People are being warned. And along the way, we kept listening to calls, call after call after call. And we heard the manipulation. We heard the other things. And I just felt like there was something you could learn about domestic violence from those calls that you couldn't get anyplace else. I think there's a lot of reasons for that. I mean, my feelings about it is it's very difficult to replicate kind of being in my household growing up, or to replicate being in a victim's home or listening to what is actually happening. And they put you there.
Yeah, what I really appreciated also is that I think you documented and analyzed, gave a platform for something we had seen, the subtleties of the intimidation, the fact that some of it can look like, and we see this in stalking cases too, very benign, nothing. That's why I love the title of your article, because I think it's the illustration right there. And yet there's meaning behind it, and it underscores why the relationship, the context, the other information before, during, after the abusive incidents is so important to understanding these cases. And so I really appreciated that. And maybe this is mostly related, but did you get a sense of why then this is so missed by investigators or prosecutors, even when they have the tapes?
One, I think not everybody has the tapes, even today. My experience is these tapes are not being used in a lot of trainings. My police academy here in the state of Washington still was not using these tapes to help patrol understand what's going on in domestic violence. Detectives rotate, there's only a handful of detectives who are truly specialized domestic violence detectives, even in a place like King County. Those detectives are great because they're exposed to the tapes, they're exposed to these dynamics all the time. But those who cycle in and out are not. And so I think it's incumbent upon us as professionals in the field to try and do a better job educating. And that's what Equitas is doing. And Jennifer, that's what you're doing. That's what Amy and I are trying to contribute to that as well. I also think you have to spend a lot of time with them. And it's easy. People want a quick or magic answer in domestic violence. And it can be difficult to focus on cases like recantation when there are so many other cases where people really need our help. And so we gravitate to the people who ask. Right? The people who want our help, we gravitate to the help-seeking behavior. And those who, even if it's being motivated by some other person or some other things, those who don't want the help, there's too many cases, there's too much work, there's just a natural triage that goes on. So I do think, even within the community, it's pretty rare to find community advocates who have ever listened to a recorded jail conversation. And I will say, even when we introduced these calls, years and years ago and presented on Amy's paper, there was a lot of controversy because people felt like the coercive aspects of the calls would happen in moments, but then there would be many hours of people just talking about their life. And so there was a lot of controversy that the calls were missing the intimidation instead of people understanding that this is a more sophisticated endeavor. And it's not like a streetcar named Desire, right? The person with the bad t-shirt, who's the drunken loud doing the abuse. I mean, the abuser is a far more sophisticated entity for that, far more dangerous, far more manipulative, and has much more in common with like pimps and sex offenders than they do with others.
Yeah, very purposeful, very intentional acts. And I think that that's, when we work with people who work with offenders, obviously, we want to be understanding. You want to have some level of, not generalizing an entire category of people of what they've done. But nevertheless, I think on the flip side, there was always this tendency to try to put yourself in your offender's shoes and think of their behavior through the lens of your own behavior, your own understanding. And that is mistake number one. And I think then just minimizes that these aren't accidents. It's not a mistake. It's not a loss of control. It's very, very purposeful.
Yeah, I think today we really are beginning to appreciate the very significant behavioral health needs that many offenders have, right? There is a lot going on. We have high rates of suicide. We have high rates of mental health and substance abuse. We have offenders who are obsessed with their victims and maintaining the relationship through any mechanism that they can find. And so our techniques in the past really were grounded in male misogyny, right? We're going to take the misogyny from the offender. We're going to remove it from them. We're going to make them say the right words, that they've been kind of cured of their misogyny, and then they're going to be able to go on with their nonviolent life. And that I think will work for some, but what we're missing is a far broader understanding of who these abusers are and what they are doing. And we see it in domestic violence offenders are responsible for the vast majority of mass violence in this country. They're a driver of violent crime and violent death. There's a lot more going on. And so the treatment and the other interventions that we're doing should reflect the level of kind of intensity and sophistication that these offenders represent.
Now I'm going to shift a little bit. We have these cases we focus on, and I like to focus on the cases because they bring in the story of the victims. But this is a case, Giles v. California, we know it well, but it doesn't revolve around jail calls, but it does revolve around a lot about intimidation. And it's an example where the Supreme Court talked about exactly what you were talking about, understanding domestic violence. And in the holding, again, of a very clinical, very legalistic, very specific on the history holding on a case around the Constitution and the Confrontation Clause, the court still thought it was very important to talk about exactly what you were talking about, the dynamics of domestic violence and how they would help courts and, I guess, then trickling down, investigators and prosecutors understand intimidation, understand tactics of abusers. I understand these exact things you've been talking about that would keep people from being able to participate. And I definitely want to get into the holding of the case, but I do like to spend a few minutes because I think sometimes people forget, especially when it's a Supreme Court case, that there are victims. But this was a case, Giles v. California. It's a domestic violence homicide case. It's the violent death of the ex-girlfriend of the defendant here, who was shot 6 times. And the evidence showed at least 3 of the times that she was shot, of those 6, in a very defensive posture. And just to give life to the fact that 2 things. One, this was someone's life underpinning the case, and someone died at the hands of someone, okay, at the time their ex-boyfriend and girlfriend, but someone that they loved at one time, trusted at one time, and chose to spend a life with. So just the extreme vulnerability there. And the other piece is that some of these huge cases that have constitutional implications well beyond our field, well beyond domestic violence. And we can learn so much about, do start from domestic violence cases and can be tied back to that 911 call that's taken or something else. So I just wanted to give that little background of this case, which I think is so important to, in your work, so important to helping prosecutors who are now litigating under this case. But I want to ask you first, as a very basic piece, if you could just identify the Confrontation Clause, what is that right that gives us?
Right. I mean, you have a constitutional right to, basically confront the witnesses, the evidence against you, right? It's a basic foundational right that everybody has. And the due process part of that you're able to confront your accuser, you're able to confront the evidence, and confrontation is to examine it, right? To address it and not have it be hidden from you. And so one of the inherent tensions in domestic violence is sometimes we're putting on cases where we won't have the victim, where we won't have the ability to examine the evidence in the same degree as we would as if the person was actually there. And so that leads to an inherent tension in prosecution. And I think that right is incredibly powerful, but is also one that can't be both a sword and a shield, right? You can't use it simultaneously demanding that you're allowed to confront the witnesses against you, to examine them, to call them into question, to question their credibility, and at the same time make steps to make sure that they don't participate in the process so that you don't have evidence against you. And so, yes.
No, so I was going to say, and that's why I love this case, because it's not, there's still steps we have to take and show. It's not like all rights disappear, but if you are a defendant and you have procured your witnesses' inability to be there in court, they're not there, they're not testifying, and you've done it for the purpose of keeping them out of the hearing or from testifying against you, you don't get to argue that anymore. It's like you don't get to benefit by your own rights, aptly called forfeiture by wrongdoing. I guess that's what we're talking about. But can you talk a little bit, because obviously most offenders, most abusers aren't committing the violence and saying, and I'm doing this so that you don't testify against. Some do, and I'm sure you've heard that on your jail calls. But for the ones that don't, how are you analyzing those cases?
Well, I mean, the issue and in the hard part here is a lot of the fact patterns are not clean. So you're going to have instances of this campaign in how we talk about it, these calls or this other ways that offenders are trying to dissuade victims from participating in the process. And sometimes that is happening, oftentimes that's happening through sympathy appeals that they want to get back together. And that's what the victim wants at certain times as well. And so you're having kind of mixed intent that's being expressed. It's never just, I don't want you to participate. Sometimes people say that and then they'll do like, write this down, recant, RECA, and, they'll be very specific about doing it. And those cases are easy, right? But there's a lot of cases where the victim's agency ebbs and flows. And we talk about this in the book, that there's a dynamic process of the 5-stage model of how victims and offenders are interacting with each other, of when their agency is up, when they're kind of confronting the facts and confronting the challenges in the relationship and the violence, versus their willingness to do this. And sometimes it's the victim's suggestion led to them, they're led to that by the offender's manipulation. But your record is also going to contain that the first time, if I'm defense counsel, I'm like, the first time this came up is when the victim said it. And so, you have a complex dynamic, which is what makes Amy's kind of conception of the 5-stage model so important. Part of the problem is you can't, Amy does a ton of expert testimony, but you can't have her everywhere all the time, or people from Equitas there all the time. And so how are you communicating to courts a more complex idea without having a clean set of facts about what is happening?
And you talked about the lack of resources or just the fact that there's so many cases. So if you were to distill for investigators, let's say, of things they could do at the investigation stage to try to document a path, understanding this complex evidence that the prosecutor is going to have to take, what sort of things would you tell them? Maybe the top 2.
Yeah, well, for us, we focus a lot on this. And I know a lot of jurisdictions use kind of supplemental forms in what they're doing. I think it begins with the patrol response, right? Patrol getting good information systematically from victims. Yes, risk and lethality, but importantly, just history, right? What is the history of the parties? What has happened before? And just having an understanding of that, and the patrol officer engaging with that victim at the scene. And I do think this is a huge opportunity in our field. We spend so much time on trauma-informed interviewing and procedural justice, but we do that for detectives in follow-up and not for patrol officers where it's really needed. And there's a lot of patrol officers who are really amazing at doing this, but they're working under time constraints. And so how can we build in and duplicate the patrol officers that are really good at doing this with body-worn camera and with other things to just have people talk about their history, first and foremost, with the offender. And I think that's just like critically important. And then some of the details of that history, right? What has happened in the past? What is the type of abuse that has gone on? Have they tried to prevent you from testifying or sharing information before? This is not the first time. And so I think it's the historical inquiry, which may not, all be admissible, but is that context that you need for charging decisions, for bail, and most specifically for courtrooms. And that can be patrol doing it, that can be detectives doing it, but you have a very short window in which victims are willing to talk about it, because right when this, a lot of the calls that we have in this case, in this book, it's 6 hours after the incident. He's been booked in, he gets an opportunity to call, he immediately starts calling then.
Right.
Before we have a chance to get a no contact order in place. And so you have to meet this level of intensity that offenders are bringing to this manipulation, this coercion, and this tampering and intimidation.
You talked about maybe it's inadmissible evidence for legal reason, but it's still helpful for us. And I think sometimes law enforcement and patrol, I can even remember this from the early days of doing the domestic violence lists in Philadelphia. They'll think, well, this isn't relevant or this, this person blurted it out before we gave them Miranda. And it's always trying to explain to them the information is really relevant. I may not be able to, it may not be admissible. We may get it suppressed, but it's important for me to hear what was happening so that I can understand it. It helps understand the case in so many ways. And I think that message to law enforcement too, that bringing us everything you have and letting us parse through it is really important in these cases.
Yeah, no, I think it's a great point. And I think, this is true for everybody, is the why behind what you're being asked to do is critically important. We are part of mission-driven organizations.
Right.
The health of the organization is how people connect with, buy in, and support the mission and understand their role within executing the mission. And so for our colleagues in patrol who are such a powerful force in the community, just sending them out and saying, hey, I need this for trial is often not enough. I think when you pair what you're talking about to this is what this guy is doing. This is a recorded jail conversation. Hear what it is that they're trying to do. And because I do think and there's some great studies out of Arizona and other places of kind of the corrosive quality that recantation and disengagement can have on patrol response. They know they're going back to the same house. They're trying to dissuade people not to stay in violent and toxic relationships. Sometimes the words they use to dissuade people are not the words that maybe an advocate would use or a lawyer would use or others would use, but it's a patrol officer as an expression of care and of concern, trying to stop the violence in their own way. And so that's an awesome thing. Right? It really is. And so we want to support that, right? But you want to build on it.
100%. And I guess just sort of ending off with this case, I know these, forfeiture by wrongdoing motions, still, they're not common and they're not always successful. But what are some of the successful prosecution arguments you've seen in these cases or you would teach someone to make?
Yeah, I mean, I think it's building it around the sympathy appeals. Right? It's so often in these cases, the offender is saying things which are not is this specifically aimed at silencing the victim? It sounds like he's talking about building a better life together and he's going to put a ring on her finger and they're going to get married. And there's all of these kind of sweet nothings and projections into the future. How could that be specifically aimed intentionally at making sure she doesn't show up to testify? And so tying that, of course, in the book and in other places, we know what he is trying to do.
Yeah. And I would just say again, I mean, this isn't a PR press tour for the book, but I'm here to tell you, I was reading that book on a training and I literally handed it. I don't have that book anymore. I have to buy a new one because I handed it to an attorney who was supervising a trial with intimidation. And I said, you've got to read this. It basically is the blueprint for what you have to do. So I am here. I'm selling your book here. It's fantastic. I was like, this was not planned. This is real.
I think it helps us really understand, for a patrol officer, when you're seeing recantation and disengagement, it helps you understand the why. And then it helps you okay, well, I really need to engage and build a good relationship with this victim so she would trust me and we could have a real conversation about what is going on. And the same thing is true for prosecutors. The same thing is true for victim advocates and others. These are incredibly powerful techniques that are used in a lot of different circumstances, but especially here. And so the hard part is some people will say, well, actually, this is the victim's agency is the thing that should control everything. What the victim wants to see happen, that's what we should be doing. I totally respect that. I totally understand it. But the victim is being manipulated by the offender. And so if we just kind of remove the jail calls from it, it would make it appear that the victim in the recant and in other things is purposefully not wanting to participate as part of maybe their feelings towards the court system or law enforcement or what have you. But there's another side to the story.
There is, and you definitely opened a lot of people's eyes to it and continue to. And just, again, as a plug for prosecution, I don't see David that much, but again, listening to you, I always learn something new when I hear you talk and talk to people. We started as prosecutors at the same time. We move in and out of the same places, but of course, he took my call, was very eager to come on. And again, as you talked about, a mission-driven organization, and as such, I think it binds us together. So thank you for being a legal champion. I think that the world needs more of them. And so I wanted to just end with 3 quick questions that I like to ask everybody just about you. And I guess the first thing I want to ask you is, what's the hardest lesson that you've learned in the courtroom?
I think the hardest lesson for me that I've learned in the courtroom is the outcome is not about me, right? It's not about me. And even though lawyers are, very competitive people by nature and want to succeed, they want to win, they want to prevail with whatever position there is. In the end, this idea of what is kind of a just process, a just system, and doing your part to make sure that those ideas are upheld, kind of this idea of the rule of law, right? That we're all part of this larger, more important idea of rule of law, that when things don't turn out because jurors didn't like some aspect of your case or didn't believe certain aspects of it, or, maybe believed some of it, but not all of it, I think we give ourselves probably way too much credit when there's success, and we take too much responsibility when there's failure. And so this idea of being clinical, maybe learning some lessons from our colleagues in medicine, right? About how they can deal from patient to patient to patient, and things happen and you're responding, you're doing the best you can with what you have, with where you're at.
I love that. What would you tell young David Martin about this work?
Enjoy it. Yeah, I do. I think it's, for a long time, we all come into the law and the opportunity to do something that you deeply care about is pretty rare, right? It's been a huge blessing for me to be in an office that cares a lot about domestic violence, to be in a community that cares a lot about it and is willing to kind of go there and do things. And so I guess probably along the way, it would have been nice to slow down and appreciate that more. Right? Instead of getting on to the next thing, the next case, just constantly rushing as young attorneys are wont to do.
Yeah, that was fantastic. And then last one, what keeps you coming back, even when it's tough?
I believe in the mission. I believe that we make a difference. I really do. Yeah,
you do.
Absolutely. Well,
you do make a difference.
I thank you for that. And I'll say, I look over time and there is less domestic violence, homicide, less domestic violence death today than there was when I started. That's absolutely true in my community. And I know that to the, 10th and 100th of a percentage point. And you realize you're part of a team and you're part of a group of people who are trying to make a difference. And that is, that's what keeps me coming back, is the people I get to work with, the mission, in the idea that the work matters. And you're contributing. And this is like, even this book is just like my and Amy's like small contribution to the world, right? To make it a little bit better. We're all part of a community of practice in trying to respond to DV. And so, yeah.
Well, thank you for making the world better. And thank you so much for being a guest today. I could listen to you all day. And just thank you for everything, David.
Jennifer, thank you so much. I appreciate it.
This podcast discusses the violent crimes of sexual violence, domestic violence, stalking, and human trafficking. If you need support, please check the show notes for links to hotlines and agencies that can help. For more information about Equitas, please go to equitasresource.org. That's AEQUITAS resource.org, or follow us at Equitas_resource on Instagram. This series is executive produced by Jennifer Long, Equitas, and Robin Hopkins. This series is sound designed and edited by Dan Kroll. This season of Just Champions is funded by a generous grant from the U.S. Department of Justice Office on Violence Against Women, supporting efforts to improve justice in cases of sexual violence, intimate partner violence, stalking, and human trafficking. The opinions, findings, conclusions, and recommendations expressed in this podcast do not necessarily reflect the views of the Department of Justice Office on Violence Against Women.